this BUL Emerging Law Voices series and to the new episode where we have the pleasure and the honor to host a major British diplomat, in essence, UN legal, UK legal advisor to the United Nations, Mr. Chanaka Wickremasinghe. We welcome you, Chanaka, and we can speak maybe in the singular since we had an acquaintance for some years before. It's an honor and a pleasure to have you here on this series, speaking about international law, especially since you have the opportunity to serve in a cardinal post of British diplomacy. So the first question would be, how is it the experience now to serve as a British diplomat in the United Nations?
Well, thank you very much, Solon, and thank you for this invitation, which is indeed a pleasure and an honour for me to meet. For me, the joy of this job is the ability to meet lawyers from all over the world. There can't be very many jobs that, if you want to know the position of Latvia, Namibia, and Cambodia, you can just ring somebody up or arrange a coffee with somebody and go and meet them. It's a great privilege and honour to serve in this role as the legal advisor to the UK mission. I'm not an advisor to the UN. I advise the UK government.
Yeah, it has to be clear. I made a small mistake in the beginning, but it has been rectified, so everything is clear to all viewers. Yes.
Not at all. But yes, it is a real honour to sort of serve in this role and to meet colleagues from all over the world, to share legal ideas, to think about the way the UN is evolving, the role of international law in current affairs. And so, yes, it's a great opportunity for any international lawyer, I think.
Chanaka, this lapse of tongue of mine also brings me to a very interesting question, which I have to admit I hadn't thought of asking, but now with this opportunity I will ask. You still remained a British diplomat and not a UN official. What are the advantages and disadvantages of serving international law as a national diplomat vis-a-vis having been maybe a UN official?
Well, I can't speak as to how a UN official treats international law, but for a state legal advisor, I think states are very conscious generally that they are the primary actors in international law. They are still the primary subjects of international law, and therefore, when we are advising or when we are interacting with colleagues from other states, we feel that it is the action of states that is of primary importance in interpreting international law, in developing international law, and in prescribing international law. So we feel a kind of strong responsibility in this respect as state legal advisors to advise accurately and effectively on international law that will not only serve the question of the moment, but also will serve the wider international legal system.
If I can play the role then of the UN official, if I can also enter their shoes, maybe they would advocate for less state intervention in international law. Do you think that maybe UN official would argue that also other entities now should have a more preponderant role, or the UN organs?
Indeed, I think that there is a point that the lawmaking process isn't simply about states. It's that there is a role for international organizations, sometimes directly. We see the European Union acting very much as a primary actor in some fields. With regard to the UN is, of course, an organization that's made up of member states. And so in order to be able to take action, the UN Secretariat would need a mandate from one of the political organs or one of the organs that are made up by states. But at that point, the UN has its own legal advisors advising them on how to carry out those mandates in a lawful way. So there's certainly a role for legal advisors to international organisations to play a role in the lawmaking process as well. And similarly, civil society organisations, they feed into the process. If you take, for example, the recent treaty on biodiversity in the high seas, that we are almost ready to sign, I think. In June, I think, is the text should be ready. But the civil society organisations had a great role in the promotion of that treaty and in getting states to focus their energies in development of that treaty.
As a legal advisor of a major state in the international arena, have you ever felt that in the UN we have two different universes actually acting in parallel with each other, meaning the UN organs which try, as you said, to create a sort of law, and then you can comment about, if you want, about if we have a UN law, the so-called, because there are some academics in the past, they have explicitly referred to UN law, which according to their view is a bit different than the standard international law, which is supposed to be produced only by the states. And then the state view that you expressed before, do you think that there is a kind of collision between two different parallel universes in this organization, the UN?
What an interesting question. For me, I don't see it as quite a paradigm of two colliding paradigms entirely. I think that there are different emphases, perhaps, for different international lawyers in the system. And so there will be times when a state is very much pursuing its own sort of national agenda within the UN. There are other times where it is standing back and saying, well, actually, this matter, I mean, either it suits us to take a very internationalist view on this. This is a kind of very basic rule that is applicable to all of us, and we must maintain that. Or a state might, for example, say, well, this development is something that we're not so worried about ourselves nationally, but we're very happy for other states to go ahead. So I don't see UN activity as, I mean, I don't see them as being sort of
with state
opposing.
Practice
Yeah.
also, yes. Because
Yeah.
we have also a plethora of UN organs. Maybe our viewers will mostly know the UN Security Council and the UN General Assembly, but we have other organs. And my question is a twofold question. The first part of the question refers to the two major organs of the UN, the General Assembly and the Security Council, especially after the war in Ukraine, the situation there, also before the situation in Syria. Do you think if the General Assembly is going to take a more preponderant role in the formation of international law? And the second part is, what is the role of the other organs of the UN, meaning law students, because also maybe now international law students are listening and watching us. In essence, should they learn also about UN organs, or in the future it's going to be enough? We're going to stay to this basic dichotomy between the UN Security Council and the General Assembly.
That's very interesting. I mean, first of all, I would say that we need to be clear about the different roles of the organs. The Security Council, which is there to maintain international peace and security, it's not primarily a law-making body. It does, of course, produce texts and can produce international obligations for states when it uses its mandatory powers under Chapter 7. But I don't think it sees itself as a legislature for the world. The General Assembly is obviously established as a deliberative organ and has been has a role in the codification and progressive development of international law in accordance with the Charter, and that it usually develops international law through its work in the 6th committee, the legal committee of the General Assembly. And there is a sort of wide competence over all legal matters. There's ability to look at the international legal system as it stands, see where there are gaps, see where they can be filled, see where there is the need for a new convention or not. And obviously the Sixth Committee is aided in that by the work of the International Law Commission primarily, which is an organ of the General Assembly that's established primarily for the purposes of the codification and development of international law. So I would think that in general, it's the General Assembly that we should be looking at when we want to talk about the development of international law more than the Security Council.
Despite the
That's not to say the Security Council.
Despite maybe the automatic majorities in the General Assembly.
Yes, it is hard to work in the General Assembly sometimes when there are large majorities against one. The interesting thing about the Sixth Committee, the legal work,
majorities, that's the issue. If it was only large, it would be okay. But if we have automatic majorities, the question is whether politicization delves into the whole issue.
There is that danger with some of the work of the General Assembly. And I can think of areas where that is definitely the case. What's interesting about the legal work of the General Assembly in the Sixth Committee is that there is a very strong consensus tradition. So it is not the pure majority rule. I think the last time the Sixth Committee voted was about 20-something years, or nearly 20 years ago, I think. And in general, we try and work through international legal developments on the basis of consensus in line with the consent-based nature of international law.
Indeed, the Sixth Committee is more professional, there is no doubt about this. And this is also the role of the legal advisors of the states there in the UN. But my question now is a bit more kind of provocative, or maybe not so provocative in the sense maybe you anticipate it. It's the nexus between law and politics, meaning the legal advisor, you and your colleagues, you are there in order to advise every government, not only the British government. Does it depend on the state whether the politicians are going to hear the advice of the experts? Or we see that in essence states take their own line based on political concerns when it comes to matters that pertain to the UN. How much do the politicians listen to this advice, to the legal advice, to the professional advice?
I think, I mean, if I could sort of answer it in terms of my own experience of these things.
Yes, and the general government, the general climate in the UFO of US to get an idea yes. whether a legal advisor can impact, or in essence, international law must mature more on this, so that governments and politics must go a step beside and behind when it comes to this evolution of international law.
So the areas that have the sort of generally have the highest sort of political momentum behind them are generally the issues in the Security Council, in my experience. These are where the Security Council is trying to take action to meet an immediate threat or breach of international peace and security. So one might think currently about Sudan, for example, where the Council is trying to meet and trying to work out a way forward there. There, I think legal advice feeds into the development of policy. Legal advisors are brought in at an early stage when the system is working well. And for example, if our ministers or our ambassador here is going to make a statement in the Security Council, that will be checked by a legal advisor and to make sure that any statement about the law in there is correct and accurate. Similarly, any product of the Security Council, like a Security Council resolution or a presidential statement, those have to be checked for their kind of legal correctness, and that falls to somebody like myself to go through that and make sure that that's all accurate. There are areas where the Security Council has taken a more sort of more direct role in international law. For example, next week, the prosecutor of the International Criminal Court will come and brief the council on his investigations into the situation in Libya, following a referral of that situation to the prosecutor back in 2011, and he comes regularly and briefs on his investigations. In those situations, obviously the council, the lawyers in the council have a more forward role, and often it's the lawyers in the council who are sitting in the national seats and making the statements